Afternoon.
Sorry, I was on mute. We'll get started at 2:35, just letting folks know. And I have Councilors Arroyo, Sabi George, Bach, and Braden. I know I just got a text from Councilor Campbell, who's one of the lead sponsors. She's coming on as well. So do I have all the councilors? I think so. Get started shortly.
Clarity's on, Madam Chair.
Councilor Arroyo, I just wanted to wait for Councilor Campbell, that's all.
That's fine with me. She's in the waiting room, Madam Chair.
Thank you, Councilor Arroyo. Thanks, Councilor Edwards.
Yep. All right, everyone, we're going to go ahead and get started. Good afternoon. I'm City Councilor Lydia Edwards, Chair of the Committee on Government Operations. It is Friday, April 9th, and we're here today for a virtual working session on Docket 0369, restricting use of chemical crowd control agents and kinetic impact projectiles. This matter was sponsored by Councilors Ricardo Arroyo and Andrea Campbell and was referred to the committee on March 3rd, 2021. Similar legislation was passed by the City Council on December 16th, 2020 as Docket 0811, which was vetoed by former Mayor Walsh on December 31st, 2020. In accordance with Governor Baker's March 12th executive order, we're modifying certain requirements of the open meeting law, which allows us to do our jobs, but also balance the public safety needs of the day. The public may watch this working session via live stream at www.boston.gov/city-council-tv and on Xfinity 8, RCN 82, and Verizon 964. It will also be rebroadcasted at a later date. Written comments may be sent to the committee email at ccc.go@boston.gov and will be made part of the record and available to all councilors. Quick review of the legislation and who is here today. And then we're going to go straight into the working on the, I'll have the lead sponsors, I'll have councilors make some very brief comments if they choose, and then we're going to get to work on the language. I just wanted to note the administration, or at least the Boston Police Department, I shouldn't say the administration, is not here. They were invited to be here today, and they did show up in last year's working sessions and hearing. This legislation will limit the use of chemical crowd control agents and kinetic impact projectiles by the Boston Police Department and other law enforcement officers in Boston during lawful protests, demonstrations, or other gatherings involving 10 or more persons. The legislation provides an exemption to this limitation if an on-scene supervisor authorizes the use in response to ongoing acts of violence or destruction of property. The on-scene supervisor also authorizing the use must have personally witnessed the violent acts or destruction of property and determined that other methods of de-escalation will not be successful. Before the use of these crowd control agents, 2 separate warnings must be given at least 2 minutes apart over a loudspeaker system. There's also a 2-minute wait after the full reading of the second warning before any chemical crowd agents or chemical impact projectiles can be used. The legislation contains enforcement provisions that require notice and reporting requirements. Violations of the ordinance could constitute an injury for which any person may institute proceedings to enforce. Prevailing individuals would be entitled to recover treble damages. That's 3 times the amount than their actual damages. Participating in well, again, as I noted, the the Boston Police Department is not here today. I have on the acting mayor, Janie, was part of the city council at the time and voted in the affirmative for this. So I don't want to say administration now because that'll be a confusion. So acting mayor Janie, I believe, is in support of this. The Boston Police Department is chosen not to be here today. Joining us as guests are Rasan Hall, who's the Director of Racial Justice Program at the ACLU of Massachusetts, and Attorney Jeff Bureau, who's from the National Lawyers Guild of Massachusetts. We will allow for them to speak. But afterwards, after each one of the city councilors can say brief remarks, and I will introduce them in the order that they have come in. I have Councilor Arroyo and Councilor Campbell, who are the lead sponsors, Councilor Sabi George, Councilor Bach, Councilor Braden, Councilor Flaherty, and Councilor Mejia. Have I missed any of the councilors? Very well, councilors, we'll go to the lead sponsors, Councilor Arroyo and Councilor Campbell, for any brief remarks. This is still a working session, and while the Boston Police Department may not be here, I did bring along the veto letter and the reasons in the veto letter from what I believe is them and former Mayor Walsh, and we can discuss aspects of that if anybody in the working session wants to do that. But honestly, yeah, it's a disappointment to be we're ready to work, and we're ready to do and put in good faith and work on a piece of legislation. It's I'm really disappointed the Boston Police Department is not here. So those are my thoughts. But Councilor Arroyo and then Councilor Campbell.
Thank you, Madam Chair. I think you did an excellent job summing up sort of what this ordinance does and sort of the purpose of this ordinance to protect civilians and residents from objects and projectiles that may actually be lethal and in this city have actually been lethal in the past. Some history on this, just for folks who may be tuning in to this as their first working session. This was an ordinance that was introduced June 17th of 2020. We had our first hearing on this August 10th, 2020. We had a working session. This would be the third. The first one was November 19th of 2020. We added a 90-day implementation language so that this doesn't take effect immediately, but instead takes place 3 months later, or specifically 90 days. And so we then had a second working session, December 13th, and then this was voted on by the council and passed 8-5. We reintroduced this ordinance in February of this year, last month, and this is our first working session in this official capacity. I have spoken to the administration, the mayor's administration currently on this. She is in support of this, she being Mayor Janie, and they intend to sign this legislation if and should it reach their desk again. And so that's where it remains there. I see this working session as an opportunity to hear from colleagues, from activists and advocates on this. But that's my understanding directly, is that the mayor supports this, voted for this, and will sign this if it reaches the desk. Thank you, Madam Chair.
Councilor Campbell.
Thank you, Councilor Edwards, and thank you to my co-sponsor, Councilor Arroyo, on this. And also thank you to my council colleagues that supported this legislation the last legislative cycle, right? Not everyone did, and there were participation by many who really spoke to the importance of getting this passed. I know Councilor Braden shared personal experience with this that was extremely powerful, and it was frankly a piece of her story I did not know. So it was from very powerful hearings and working sessions. So thank you, Councilor Edwards, and your team as well for shepherding us through that process. And so I'm excited for this. Obviously, I hope more council colleagues will support this reasonable piece of legislation. And we've said from the very beginning, it is reasonable. It is not an absolute ban. It establishes, I think, or codifies what the department already says is existing policy and practice. And so if that's the case, this for me has always been simple, that we should do this. And I also want to thank, of course, not just the residents who came forward to testify as to why this legislation was so critically important to get passed, many who shared very painful stories of being harmed by some of these tools during peaceful protest. So thank you to the residents who showed up. And of course, thank you to our organizational leaders, Jeff and Rasan. You guys have been here since the very beginning, offering up very helpful and constructive feedback. So thank you as well for the partnership in this work. And just really appreciate all of you on the Zoom right now. So thank you. Thank you, Councilor Edwards.
Thank you, Councilor Asafi George.
Thank you, Madam Chair. Sorry that I'm not on camera at this moment. I'm happy to be here and to tune in to today's discussion and the work that's before us. Thank you.
Councilor Bach.
Thank you so much, Madam Chair, and thank you, Councilor Arroyo and Councilor Campbell. And I have to say, you know, I had hoped we would have, our first vote in favor of this would have been successful. One thing that's unfortunate about that is that Somerville has beaten us to the punch, I think, and passed this legislation last night. So we don't get to claim to be first in the region anymore, which is, I think, unfortunate. I've shared before. I feel strongly that, you know, weapons that are banned in the Geneva Convention should not be used by our police departments. I think there are other ways. I think every weapon is convenient when you have it in your hands, but there are always other ways. And I just don't think that, I think this is far too indiscriminate. And I got a little bit of tear gas in my eyes myself when I was down in the May 31st situation in my district. And I don't think it's something that our department should be using. So I'm strongly supportive of this legislation. I do have, in the spirit of the working session front, there is one provision that Somerville changed in their version of this that has to do with the legal liability to the city that I do want to raise, Madam Chair, but I won't do it in the intro remarks. But it's a small thing, and like I said, I would like us, you know, if not to be first anymore, to be soon on this front. So thank you.
Councilor Brady.
Thank you, Madam Chair. Thank you to the lead sponsors on this very important piece of legislation. I'm delighted that we're back at the table discussing how we might pass this. I think it's a very reasonable, it's not banning these weapons, but it's asking for a very judicious and careful consideration of when they should be used. So given not my direct experience in Northern Ireland, but growing up in Northern Ireland where these weapons were used wholesale, like over a period in the 70s and 80s, 120,000 rubber bullets were discharged and 15 people were killed and hundreds maimed, many of them children, young people. I really feel this is something that we need to address. Thank you.
Councilor Flaherty.
Good afternoon, Madam Chair. Thank you for hosting. Thanks to the sponsors for refiling. I was actually looking forward to further discussion to see whether or not the department's concerns had been addressed as it pertains to difficulty to operate, to operationalize in real time. That was one of the big questions I had as to when things start to break down. There's an expression that you'd rather be looking at it than looking for it. And for folks to have to sort of regroup and in a short period of time, they may actually lose further control. And then through the chair to the makers, would they consider in the definition section to include a definition of peaceful protest? Because I think there's been a difference of opinion as to, so what is a peaceful protest and what's not a peaceful protest. And I think if we have parameters, or at least the police have parameters as well with respect to this ordinance as to when is it remaining a peaceful protest, and then when does it cross the line, and then when does the need arise for the type of tactical equipment, I guess, crowd control equipment that we're discussing now. But if we don't have sort of an underlying definition of the protest, whether or not it's peaceful or not peaceful, kind of ties everyone's hands. So if we could have through the chair, if the makers would consider putting in a definition in the definition section, a definition obviously that we as the council would agree to as what is a peaceful protest and or what is not a peaceful protest. When does it cross the line, then allow the officers to take appropriate measures. Thank you, Madam Chair, and thanks to the sponsor.
Councillor Mejia.
Thank you to the chair and to the sponsors for bringing this ordinance to the council again. We fully support this ordinance last year and look forward to offering our full support again this year. There's not much else to be said that hasn't already been said. Members of our office were at countless protests last year and narrowly escaped being gassed or shot at with rubber bullets. We don't allow these weapons to be used on the battlefield, so I don't know why we would use them on our streets and on our own people. So looking forward to the conversation.
Thank you, Councillor Flynn.
Thank you, Councillor Edwards. Councillor Edwards, I have no opening statement. Thank you.
Thank you. So, Councillor, to the lead sponsors, I didn't know if you wanted, at this point, I would, let's just go, I don't know, line by line and just go through it to make sure we're clear on this, and get to work, because it looks like, again, as my colleagues have already stated, it was an 8-5 vote that included also acting Mayor Janey, who has already indicated she will sign this last year. So at this point, I kind of just want to make sure we're all clear on the language. We can ask questions as we go by the group and by the section. That might be easier. To Jeff and to Rasan, I think you guys are great, but I don't know that you're probably going to be answering a lot of our direct questions about definitions and things like that as we go. Is that okay? I'm not saying that unless you guys have some burning opening remarks right now, I'd rather just get to work.
Let's get to it.
Okay. So everyone should have a copy of the legislation in front of them. I don't know that if there's any questions. And again, I do have a copy for those who might be interested in what were the stated reasons for the veto. I can read them, just the highlights real quick. The first was intrusion on the police commissioner's statutory authority, noting that the police commissioner has cognizance and control of the government, administration, disposition, and discipline of the department and of the police force of the department, and shall make all needful rules and regulations. So this ordinance was apparently in violation of that. At least that's the reason for the veto from Mayor Walsh. The control, number 2, was control of other law enforcement officers. Other law enforcement officers being I guess a confusion and not really knowing this, noting it could potentially apply to military police, National Guard. And so there was a concern with that. And then there was a conflict with the commissioner's statutory authority over discipline, specifically disciplining of officers. It seemed that also violated the statutory control of the police commissioner. So those were 3 of the issues that warranted the veto for Mayor Walsh. So going to purpose. Anyone concerned or have suggestions for the section on purpose? You have your hand raised, Jeff. Did you have something to say?
I was just going to respond to Councilman Flaherty's suggestion about the definitions, but it can wait until we get to that section.
Definitions. Okay, great. Thank you. In terms of the purpose, any questions, concerns of the section? Does everyone have it? Yay, please. Please. Okay, now we're in definition. Councillor Flaherty has asked for a definition of peaceful protest. Before we go into yes or no on that or whatever, I guess I'm genuinely confused about what you're asking us to do and why, Councillor Flaherty, you want a definition for peaceful protest. What? Because protests can be all sorts of things and can be intended to be one. Could you just help me understand your goal for that?
Yeah, we're obviously putting our shoes we're putting ourselves in the shoes of the officers on the scene, right? And we're telling them what they can and can't do under certain situations, but we're not necessarily defining the situation. And what we see, or at least what we saw, was that we saw what I think intended to be a peaceful protest got out of control and then turned into non-peaceful protest. But if we're going to limit our officers in their ability to use certain tactics and materials at their displeasure, then so we need to figure out, I guess, give them sort of, I guess, the barometer of when it crosses the line, or at least let's define what a peaceful protest is, and then when does it deteriorate into non-peaceful. I think that would be helpful, particularly if we're going to be enforcing the ordinance, or if someone's going to challenge the ordinance from the very get-go. I think we need to describe, and maybe folks have an opinion on that. Again, through the chair to the sponsors, or to Jeff, I know is eager to answer, but that was just my issue, because I know there's a discrepancy as to whether or not all of those protests were peaceful or not, and if when they downgraded to non-peaceful and the officers had to take certain measures, and what ability are we tying their hands to restore order and restore peace in the streets.
Understood, Councilor Flaherty. Thank you so much. I'm going to go to Jeff to respond, and then if we can go to lead sponsors and work through other counselors. Jeff and Rasan, I mean, you both collectively if you want to. So Jeff.
So Councilor Flaherty, there are in fact exacting definitions in here. It's in section 2, section C, I mean, under exemptions and exceptions. It specifically says that they are authorized to use these weapons once an on-scene supervisor witnesses specific ongoing acts of violence or destruction of property, and the supervisor has determined they cannot be controlled or quelled through any other methods. So whether it's a demonstration, a basketball game, a protest, or anything else, if an officer, an on-scene supervisor, witnesses ongoing acts of violence or destruction of property, they can be authorized to use these weapons. We don't need a definition of each type of gathering and whether what's peaceful or what's not peaceful. It becomes not peaceful or authorizes the police to use these weapons when there are ongoing acts of violence or destruction of property. Very clear.
Thank you, through the chair. Thank you, Jeff. Which section is that again? I'm just pulling up my
Section
definition.
C2A.
I.
C2I. Okay, got it. I have it here. Thank you. Thanks, Jeff.
Councilor Arroyo.
Yeah, I was going to point that part out, but also you read the letter of the, so that's all been handled, but also you referenced the letter to the veto about the statutory powers of the superintendent. I should have made that more clear in my opening. We made one amendment to this version from the last version, which is we removed that part where we specifically stated what the commissioner was supposed to do as a disciplinary measure. And so we removed that from this, and now that conflict does not exist in this document as I understand it.
Correct. Yes, I apologize. I missed that too. I forgot to mention that as well. So 2 of the 3 concerns about the veto were about encroaching on the power of the police commissioner, as Councilor Arroyo just noted. The language that mentioned the police commissioner has been removed. Councilor, were you done, Councilor Arroyo?
Yeah, that was it. Thank you, Madam Chair. I just want to address those 2 things.
Councilor Campbell. This is on the topic of definitions and specifically of peaceful protests. Councilor Campbell.
I have nothing else to add.
Thank you, Councilor Sabi George.
None from me, thank you.
Councilor Bach.
Sorry, I couldn't find my unmute. No, I don't think I have further comments on this.
Councilor Braden.
No further comments.
Councilor Julia Mejia.
No further comments.
Councilor Flynn.
Thank you, Councilor Edwards. Councilor Edwards, I just want to ask, what would the status be if we have a, maybe I should know this answer, but if we have a temporary police commissioner, or we don't have or we don't have we have an acting police commissioner, is there any difference? Is there any difference that this would make, or would it just be the acting police commissioner?
So that we've removed all language concerning the police commissioner.
Okay,
So it would not, I believe, and the only entity and city folks that this would have, we defined it to apply to Boston police officers and other law enforcement officers.
okay.
I'm going to go back to Councilor Flaherty. Are you satisfied with the definition and discussion, or did you still want to have a peaceful protest definition, and what would it look like?
No, I'm satisfied. I actually didn't have that sheet in front of me, so I appreciate Jeff's response, and it's directing me right to the right spot. So thank you.
I have a question on definitions. And I want to, and it's more also a clarifying to make sure we're clear. I know we say other law enforcement officers, right? So that would include, when we have mutual aid, we discussed this, right? If Everett or some other police entities were to come in. But the definition of law enforcement officers can be so broad, and I'm okay with that. I just want to make sure it would include also potentially ICE. It could include, when you talk, how big is law enforcement officers? Yeah, I mean, I wouldn't assume it includes any of the, like, for example, the licensing board has like officers that goes into restaurants and stuff and takes away their liquor licenses and stuff. Could this definition be so broad that it includes them? I'm okay with this. I just want to make sure I'm understanding. And if, ultimately, I guess, Councilor Arroyo, it probably would only apply to those city officers that actually walk around with a rubber bullet or, yeah. So I apologies. My question has been answered through my own analysis. I see you have raised your hand, Councilor Bach.
I was just going to say, Councilor Edwards, sorry, I didn't know which way you were going with that the issue did come up, I think, in the Somerville conversation. This wasn't the thing I was going to raise, but I was looking and seeing how, because their ordinance is very similar to the ordinance we're looking at, that we don't technically have the jurisdiction to regulate the state police or the National Guard and such.
We don't.
And so the way that Somerville responded to that, and I'm not sure it's necessary, but I'll just say, is that they said other law enforcement officers shall mean, and they said, comma, except to the extent prohibited by law, comma, any law enforcement officer. So they basically like gave themselves a little, like, obviously we can't do something we can't do, but to the extent we can, like, that's what we're trying to do. So, I mean, that's a drafting thing. It's not really a hill I would die on, because I'm not sure it matters either way, but I'm just flagging that issue did come up, and that was how they dealt with it in the legislation.
Thank you for that. To Jeff, and then to the lead sponsors before we go on to the next section. To Jeff.
So there is some authority to regulate other law enforcement officers. So the definition is intentionally broad to cover anybody who is authorized to enforce laws. There's a 1999 SJC case in which the SJC says that a police officer lacks authority to act outside his or her jurisdiction unless specifically authorized by statute. The implication of that is that when they are operating within the city of Boston under the authority of the Boston Police Department, they're subject to the same statutory mandates as any Boston police officer would be. Now, if they're operating in Boston under their own authority, if it was ICE and not under the control of the BPD and not under the control of any other Boston law enforcement agency, then the city would not have the authority to regulate them. I also want to point out that the state police in Massachusetts rules of conduct, their own rules of conduct, says that members shall obey all laws of the United States and of any county, state, or local jurisdiction in which the members are present. So they are required by their own rules of conduct to obey the rules in the city of Boston. In addition to which, there's a federal district court in Denver which
So
issued.
Jeff, I think I think I answered I don't think the issue is a controversy as much anymore. I was just trying to figure out how broad it was, and it's intentionally broad. Councilor Arroyo and Councilor Campbell, Councilor Block brought up some like that clause about, is that something you would be open to, care about?
Actually, Jeff, you helped with the Somerville one as well, correct? They came to you as sort of an expert on this. So I'm assuming if that clause was written, you might have actually had something to do with that?
That's correct.
Okay.
We did that in response to an objection from the city solicitor in Somerville.
And so as far as you're concerned, if we added that amendment here, it wouldn't really change the nature or we could do that here.
That's correct.
Yeah, so that's fine.
Okay,
Sounds
Councilor
good.
Baden? Oh, I'm sorry, Councilor Campbell. I'm so sorry. You know,
No, it's fine. Sounds good.
Can't run
Thank you,
away.
Councilor Edwards.
I defer to one of the co-sponsor,
Okay. Thank
and then
you.
I'll ask my question.
Sure. So the topic of other law enforcement officers, we're going to move on from that. We're still in the definition section though. So if you have a question that's beyond the definition section, where I've asked that councilors wait till that.
Definition, I had a question. Boston police officers shall mean all cadets, patrolmen, officers, detectives, and superintendents of the Boston Police Department. I'm wondering, do cadets carry firearms?
I believe, and somebody else may speak to this with more authority on this, but I do believe that in some situations where they are short on officers, cadets do get called to protests and things of that nature. But I think it's possible that Rasan Hall or Jeffrey Fuhrer will know better on that. But I do believe that cadets at times are at protests and demonstrations.
That's correct.
I may be nitpicking, but I'm just I'm a little concerned about the level of training and preparedness to deal with a stressful situation. And I know they're not supposed to be deadly weapons, but they are on occasion. So it's just a question I have in my head about the level of training that a cadet might have to use these rarely used weapons, because we don't use them very often.
Valid.
Thank you. That's a valid concern. I do think training is actually put in here or notice at some point. So when we get to that, maybe we could discuss cadets and training or something. All right, and any other, Councilor Mejia on the definition section.
Well, since we're talking about the who and the training, I'm just curious if this would be a place for us to also consider. I'm always thinking about some of our officers who have known to have aggression issues. Like, I don't want to complicate this, Councilor Arroyo, any further, but I mean, if we're talking about definitions, I'm just curious what things that we could put in place to ensure that some of the officers who have been known to be a little bit more aggressive than others, that there's some sort of additional parameters on that. And maybe not so much so, but I'm just throwing it out there for us to consider.
I will put that on the list of things to consider overall about the goal, and maybe even in the purpose section or something. So
okay.
Overly aggressive or known to problem officers, I'll just put that down to make sure we sweep through that. Okay.
Okay, thank you.
On the definition section, going once, twice, moving on to the next section, which is section C. Restriction on the use of chemical crowd control agents and kinetic impact projectiles. Subject to the limitations set forth in paragraph 2 below, Boston police officers and other law enforcement officers working in the city of Boston shall not use kinetic impact projectile or chemical crowd control agent against any person or persons engaged in a protest, demonstration, or other gathering of any kind involving 10 or more than 10 persons. So we define, this is when this limitation comes in: protest, demonstration, or any gathering involving 10 or more persons. Right, okay. Has there been any question about, and please, I'm not trying to make this difficult, but the use of chemical agents and the impact on pets, families, seeing eye dogs, in as much as because we do have an injury section. If I'm blind, if I'm at a protest, and if this is used, my seeing eye or my aid dog, I don't know if I'm using the correct language, could be injured. So there would be no rights for me for my pet or for, am I correct? I mean, we've only defined it as for persons.
That seems valid to me. And I guess Jeff and Rasan, is there a way we could do that? Because I think that's a valid thing. You depend on them. There's actually laws against other people harming somebody's, and I don't know if it's utility dog or what their term is, but there's laws against causing them harm that are stricter even than just what happens if you abuse an animal. So I don't know how we would approach that, because I agree with you. This is simply focused on persons.
I can put that in the parking lot as things to come back to.
Yeah, and I think reference to whatever existing statutory protections might even
Just refer to it. Okay.
Possibly.
I think that's correct. There are 3 sections that really deal with injuries. And the first one, it's under section D2. Any violation of this ordinance constitutes an injury. So it's an injury, not necessarily to a person, it's an injury. Then any federal or state statute that would apply to injuries to dogs could be brought under this as well. And it says any person injured or harmed. So it does not have to be an injury to that person. It can be a harm to that person. And that harm would be the loss of the use of a service animal. That would be a harm to a person. And I think that's covered by section D4.
I think I'd still like to see maybe a reference to one of the statutes. I don't know if the lead sponsors are.
Are you asking if I'm opposed? Absolutely not. I think that's,
okay.
I think that makes sense. So I just don't know what those statutes are. We'd have to find those, but I certainly.
Okay.
May I just say one thing about that, Counselor? That is, if we put in reference to certain statutes, a court can read that as not applying in other situations because we did not mention certain statutes. So and that's how the court often interprets it, that if you list something, then you have intentionally left out the things that you're not listing. And that would narrow the effect and protection of the statute. So I would caution against listing specific statutes. It's intentionally written so that it's a broad definition of injured or harmed.
So with that caution, I actually would follow that caution, because I have found that to be true in the past as well, that they see language that is, we had this when we were talking about the rules at that last video where we're trying to figure out, is it an exception if they say these things in terms of city council rules? So I don't, yeah.
Do you mind if we park this issue?
Yes, we let's.
I think, because I don't think we disagree. I think we're trying to figure out a pathway forward. That's all. So let's go on to C2, exceptions and exemptions, unless anyone had anything with the paragraph I just read. Exceptions and exemptions. Kinetic impact projectiles and or chemical crowd control agents may be deployed if an on-scene supervisor at the rank of deputy superintendent or higher specifically authorizes such use in response to specific ongoing acts of violence or destruction of property that the on-scene supervisor has personally witnessed and has determined cannot be controlled or quelled through any other methods, and has determined that no other reasonable methods of de-escalation will be successful in preventing or controlling such acts. Any discussion? Really? I mean, not really, no discussion on this. Okay. For discussions purposes and a working, do you mind if I engage a little bit? I mean, let's start with the practical question of, is there always a deputy superintendent on the scene?
Currently in the Boston Police Department, there are 20 or more deputy superintendents or higher.
Go ahead.
And they are generally in charge of any kind of large gathering or demonstration, protest, or any sort of large gathering. The celebration.
But practically speaking, you may not have all 20 in one protest, right? You might just have one.
Right, correct.
All right, just again, play with me on this. If there's one person, but the protest is as big as, you know, all of Commonwealth Ave, that one person may not personally see property damage or something going on out of sight, because, you know, you just have eyesight limitations. This requires that that person actually see it in order for them to allow for what you call.
Can I speak to this, Madam Chair?
Yeah, let me just quickly finish, but this I see the language specifically says has personally witnessed and has determined cannot be controlled. So that person, that one person who might be at a protest may not see someone acting foolish, to me, not being part of the protest, but acting foolish, right? They may not see it, or they may, or the section of the protest that is becoming uncontrollable. But unless they see it, there's no way that this could happen. Yes, Councilor Arroyo.
So I would say one of the things that's come out of the police BPD overtime hearings, I know Councilor Mejia, myself, I know Councilor Bach have raised this, is the ways in which BPD formulates who goes to these protests, how they determine the size and level of their response. And so just on that first point about if it's a big protest, I think it would stand to reason that they're sending multiple deputies just based on the fact that they get to determine that themselves internally. But in terms of the idea here behind ongoing act of violence or an ongoing property damage, the belief is that they can, if it's something that would require the action of a, you know, what is termed a less than lethal weapon, if it's something that rises to that occasion, then there certainly would be time for an officer to arrive to authorize this, because if we're talking about property destruction and it's ongoing and they believe this is something that they're going to need to do, then I do believe that the amount of time required for them to respond to that would be present. But I would just say in terms of how many are present and how many are there, BPD is able to assess that and set that themselves, and they currently do. And in my experience as a formerly on the National Lawyers Guild board, as somebody who has actually been a legal monitor at demonstrations and protests, there are multiple on scene.
But I mean, again, to push back, so they don't see it, they don't get to deploy it. And that's, is a radio like an indirect way this is happening? No, you physically have to see it happening. Jeff.
Yes, in addition, any of these large demonstrations are covered now by drones, which the deputy superintendent has access to the video from the drones, from the news feeds, from news cameras. So they can personally witness it through the video of the police drones or from the news crews, which are being shown and which the police are constantly monitoring, because that's how they identify trouble spots that are occurring. And they also have motorcycles which can get people there very quickly to a spot, to Councilor Arroyo's point about this. But with drone technology, which is used now in every single large demonstration, they are able to witness violence or property destruction very, very quickly. And they can order the people, even without being on the scene right there where it's happening, they can order the use of these weapons.
So you think the language has personally witnessed is going to be interpreted to mean on TV or
Yes.
through a drone?
Yes, I do.
I would also agree with that.
I agree. Or any other mechanism.
So, and then in terms of, what about lowering the rank? I believe Somerville lowered it to captain instead of deputy superintendent.
I think
That
part of-
in
but I can
Somerville,
speak to this too, before you jump
Okay.
in.
Go ahead, Counselor Arroyo, say again.
So part of the issue with this is that they're called less than lethal weapons, but they have the ability to cause death. And so if we're authorizing a weapon that is indiscriminate in nature, that is going to actually have the potential of, like we've actually experienced in this state and city before, an actual fatality, that the person who is making that authorization be at the absolute level of command that makes the most sense to do that. And I think if you lower the rank of that, you've then sort of diluted that chain of command of who's actually authorizing something that is indiscriminate, that is not able to be targeted specifically on a specific person and can cause a life. The entire purpose of this was to create something where if they're making that determination, it is being signed off by the highest levels of leadership. Not, we had this question about cadets and things like that. I believe we have hundreds and hundreds of captains. We have hundreds and hundreds of folks that are underneath those levels. The lower you bring the rank, the less of a authorial like power, experience, all of that you're putting into this. And so that's why that was specifically selected. And I believe it's also based off of their code, which I don't remember if we have that still, but the thing that they sent about their guidelines for this, they themselves mentioned going up to a higher rank to do this, that it's something that they do rarely and they only authorize at the highest levels. And so this was sort of in following with that. The idea
with their regulations.
Yes. And I don't have those regulations directly in front of me, so I'm not sure if it's exactly like this, but the idea was to codify what they made clear, which is only their highest levels are even allowed to authorize this in the first place, currently.
Okay.
if I may, Counselor, in Somerville, the reason they changed it to captain is they don't have any deputy superintendents.
That would be a reason to change it to captain then, wouldn't it?
And they only have 5 captains.
Okay. Thank you. That is very relevant. Thank you for that.
Thank you, Jeff.
Okay. Are there any methods? No other reasonable methods of de-escalation. And in terms of, was there any expressed concern? I mean, this is sad. I want to be very clear. The reason why I'm doing this is because I want people to see the Boston City Council work through this language and watch us and know that we are trying to do the most practical thing that balances the jobs of our law enforcement officers, which we do value, and the safety of the public. And if they choose not to be here for that conversation, I'm doing my best to make sure that conversation still happens. That's what this is for. So I wanted to talk about a little bit of your understanding of what are reasonable methods of de-escalation in this time. Are you talking about the 2-minute warning system that is provided? Or are you talking about people trying to isolate or trying to move or trying to do whatever other de-escalation methods within their training? To the lead sponsors, Jeff, Hassan. The language I mean is that no other reasonable methods of de-escalation will be successful. What do you mean? What are you talking about when you say reasonable methods of de-escalation?
So I can speak to this part directly. The reasonable methods of de-escalation was taken almost word for word by the guidelines Boston Police Department uses. And it's also, I believe, in the state policing one that they did, though Rasan and Jeff can tell me. But that exact language is what's in the state police bill and also in the BPD guidelines. I've always told, because I have been asked this question by law enforcement when I've spoken to law enforcement about this bill, about what necessitates. I can tell you a number of different things that I think would be reasonable methods of de-escalation, which would include the warning system that we put here. But I know that they've been trained themselves personally, BPD, in methods of de-escalation. I couldn't possibly begin to list all of the ways in which I'm sure they use, including things like tone, warning, isolation, all the things you mentioned. Rasan and Jeff may be able to speak more to that, but I know that that language we took specifically from BPD.
Thank you. Before Rasan and Jeff speak, Councillor Campbell.
I echo what Councilor Arroyo said. I have to jump by 3:30, so I just wanted to name that. But to your point, Councilor Edwards, yes, I respect the fact that you want to go through the language again, but I just want to also say we've done this, right? We did it at several hearings. We did it at several working sessions where some folks from the administration or department participated. At other moments, they didn't, to actually get to language that was deemed to be reasonable. And where, frankly, obviously, a majority of city councilors voted in favor of this.
You're right.
So I just want to highlight that, right? It's not, this is,
you're right.
this is just another chance. So,
you're right.
and I apologize, I have to leave early, but I just want to name, not only do I fully support this, not just as a sponsor, but I'm really proud of the work that Councilor Arroyo, along with Jeff, Rasan, and all of us did to get it to a place that was absolutely reasonable based on concerns we heard from the department. And frankly, sometimes concerns we heard through informal channels because the department wouldn't show up. And so I just wanted to name that I have to jump in 5 minutes and really, again, appreciate the input of everyone here.
No, you're correct, Councillor Campbell. Thank you for that kind of reminder. I'm not going to, thank you. I'll just say thank you. Let's go on to the next section. On-scene supervisor witness authorizes such use of an officer equal or higher rank has given at least 2 separate warnings. This is the warning system that we discussed before. Those 2 separate warnings over loudspeaker system directing the persons involved in the gathering to disperse after ensuring that people have a way to exit after a warning is issued. B, notifying all who have been affected that a failure to disperse will result in the use of specific kinetic impact projectile or chemical crowd control agent that must be announced. And C, notifying all who could be affected and that the specific kinetic impact projectile or chemical crowd control agent will be deployed within a clearly defined period of time. Such warnings must be at least 2 minutes apart, and there must be 2 minutes after the second warning has been fully read before any use of the specifically announced kinetic impact projectile and or chemical crowd control agent. Are there any questions, concerns, thoughts about this language? As a point of clarification, this requires them to say we're going to use tear gas. We're going to use blah, 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 pepper spray. We're going to use blah, blah, whatever it is, right? Okay. Would they be held liable if they said we're going to use tear gas and they use rubber bullets instead?
If they caused injury from that, yes, it would be a violation of the ordinance. Absolutely.
Thank you. All right. Section D, enforcement. Boston Police, number 1, Boston Police shall take appropriate steps to implement this ordinance forthwith, including but not limited to. Here's the training, Councilor Mejia, posting a copy of this ordinance, or Councilor Braid, I think. Posting a copy of this ordinance in a prominent visible location in all police stations within the city of Boston, notifying all other law enforcement agencies that may operate within the city of Boston about this ordinance, and supplying a copy of the ordinance to each of said agencies, and incorporating the limitations on the use of force set forth in section C of this ordinance into officer training regarding the use of less lethal and non-lethal force in policing. Any thoughts on the training section? And notice and okay. Any violation of this ordinance constitutes an injury, and any person may institute proceedings for injunctive relief, declaratory relief, writ of mandamus in a court of competent jurisdiction to enforce this ordinance. An action instituted under this paragraph shall be brought against the city of Boston, and if necessary to effectuate compliance with this ordinance, any other governmental agency subject to this ordinance. The lead sponsors would like to keep out any specific named ordinances that deal with pets, right? No calling out.
Yeah, I don't want to limit it. And I do agree that harm, to me at least, if I were legally arguing a harm, losing a service animal would be something that I think would meet that threshold, or even having harm conducted to that animal, even if I did not lose them in life, that any harm I would see as construed to myself.
Okay.
So I think that covers that.
Well, if anyone ever wanted to look at the intent of the statute, they can also watch this footage as we're discussing it, and fully intended for that language to include that in case anyone ever sees this and needs to cite.
I expect that they will.
Councilor would quote me. Actually, quote the lead sponsor, excuse me, Councilor Arroyo and Councilor Campbell. Number 3, in any civil or criminal action brought under any state or federal statute or constitutional provision arising out of the use of force by any law enforcement officer within the city of Boston, the prohibition contained in section C of this ordinance shall be deemed to be clearly established law of the city of Boston, and any violation of that prohibition may be considered unlawful. Any person injured or harmed as a result of a violation of this ordinance may bring an action in any court of competent jurisdiction seeking damages, reasonable attorney's fees, court costs, and any other relief that the court may deem appropriate. A prevailing plaintiff injured or harmed by violation of this ordinance shall be entitled to recover damages in the amount of 3 times their actual damages. Nothing in this section shall be construed to limit any individual's rights under state or federal law. Councillor Bach.
Yeah, thanks, Councillor Edwards. This one, and I'll just say definitely kind of mea culpa. I did not note this when we voted on it last time, and I only noticed it in prepping for this hearing, going back and reviewing what Somerville had passed last night. I do, with the Ways and Means hat on, have some concern about us prescribing treble damages in an ordinance against ourselves. I don't think that's something we do anywhere else. And my concern, of course, is that when we pay damages, they come out of the operating budget. They compete for city dollars with everything else. And obviously, we, the councilors passing this, are also have this fiduciary responsibility to the city of Boston legally. And I think it would be a very unusual step for us. And I'm not concerned. I think it's sort of like leave that to the judge. Like if a judge thinks that there's been an egregious abuse, like then they step in and do that. I haven't had any concerns about the prior sections with the police because frankly, I would love for this to be a ban. So it's not about kind of us. I want this to be enforced as fully as possible, but when I think about what the cost is to the city of Boston, the idea of prescribing against ourselves treble damages strikes me as not a good precedent to set. And when I looked at the Somerville thing, this is what threw it up for me. Somerville got rid of that section 4 and instead, actually, I'll just very quickly, Madam Chair, share my screen if that's okay, just because I think.
1 second, before you do that, would you be okay with the word may? That allows the judge to have the discretion to get up to triple damages.
Well, I think the judge probably, I'm not sure.
Shall, right? So if you put in the word may.
I
would certainly consider that an improvement, I think.
I'm willing to make, by the way, as the sponsor.
What'd you say?
I'd be open to changing shall to may. That's
okay.
Yeah, so I'll just, if I can, Councillor Edwards, just briefly show that what Somerville did was they basically took all the detail out of this section. I'm just gonna, if I share my desktop, does everyone just end up seeing the Zoom screen?
There you go.
Okay, wait 1 sec. Do you see 2 docs now?
I see.
Yeah.
So they left all, we have the same 1, 2, 3, and 5 is down here. But like for 4, they said, okay, yeah, it's gonna have all the normal stuff for violations. And then also obviously individuals of the right of state and federal. So what they didn't do was basically prescribe against themselves all the things like, oh yeah, we're going to owe you attorney's fees and court costs. And I mean, obviously we're always going to owe them anything that a court deems appropriate. And then the treble damages. So that in their case, I think for similar reasons from the city sort of solicitor side, they were like, this just isn't something that we do where we put ourselves on the hook financially like this, and we sort of leave it up to the judges. So that's like I said, it's really kind of a Ways and Means, like fiduciary responsibility gut check thing for me. And I hadn't flagged it previously. So I just wanted to raise that.
Okay, thank you, Councillor Bach. I see Jeff's hands raised, and then we'll go to Councillor Mejia after Jeff.
So there are a couple of issues. I appreciate what you're saying, Councillor Bach. A court cannot award multiple damages unless a statute authorizes it. As Councillor Arroyo said, it could be a may and leave it up to the judge at that point. They also, a court cannot award attorney's fees. And in all of the federal civil rights statutes to protect people's civil rights, there is a specific authorization for attorney's fees, because otherwise, if it is not a huge injury, it makes it very difficult for any injured person to bring a lawsuit on their own. They cannot afford the attorney's fees for doing it, and attorneys will not take a civil rights case against the city, which has hundreds of lawyers on its staff on a contingent basis, unless the lawyer is kind of assured of getting a payday if they win. Cases like this can often take 2 to 3 years of litigation. And if a person is injured with, say, a broken arm as a result of being hit with a tear gas canister or a kinetic impact projectile, it would be almost impossible for them to bring any sort of lawsuit to gain compensation for. Leaving it up to a judge to decide whether the behavior was outrageous or egregious and worthy of multiple damages certainly makes sense in many ways. But I think the attorney's fees provision is absolutely essential to having a person who does get injured by egregious police behavior the ability to bring a lawsuit and obtain compensation.
Sorry, Madam Chair, can I quickly just ask? So, I mean, that makes a lot of sense to me in terms of, knowing how this works on the legal side. I guess, does that mean then, though, that with Somerville cutting that piece out, that you guys are concerned about in practice people being able to bring legal action under that statute?
Yes, and frankly, I was the chief author of the Somerville ordinance as well. And working with the city councilors there, it unfortunately was a political compromise that they were forced to make in order to get the ordinance passed.
Mm-hmm. Mm-hmm. Okay.
It would seem under, just to kind of move the question, this along, no offense, Councillor Bach, I know Councillor Mejia is waiting patiently to get in. It seems like in order to then under Somerville, they may have to go under additional civil rights legislation or some other legislation as well, if they were to get those other damages. But I'm going to go now to Councillor Mejia.
Hi, yes, I'm just curious, and in terms of, I don't know how controversial this will be, but I'm going to throw it out here. This is a working session. We can figure it out. But instead of the lawsuit being against the city, can it be against the individual officer and let them know? Okay. I look, all those heads shaking up in there, letting me know, because that way, if they're having to take individual responsibility, then they would know how they're going to show up, so that we wouldn't be having this conversation. But that's not the case. Okay, I just figured I'd throw it out there and see what's.
It is not the case, but if anyone's injured personally between me and somebody else, they absolutely can just make sure they sue me. But they were acting under city authority, so the city is who's got to pay.
I know. That's a whole. I just think that's a whole separate conversation that we should explore at some point in terms of accountability. And I would urge Councillor Arroyo and Councillor Edwards to think about this as a 2.0 measure in the future for us to explore what accountability looks like, because I think that will probably prevent things like this from happening.
Thank you. Councillor Bach, and then we're going to go on to the last section.
Yeah, I would say, I mean, to Councillor Mejia's point, obviously that's been a big part of the debate over qualified immunity, and I think it's a really good point, Councillor Mejia. That's why what I'm saying is I'm coming from a Ways and Means place on this, because it's not like the people who are accountable financially is the city of Boston. So if somebody really screws this up, then it's the city that's liable. And I think we are balancing. I mean, I totally take Jeff's point. There's got to be sufficient financial benefit to the lawsuit for people to be able to bring that to enforce the ordinance, and make it so that behavior like changes, and that's important. The flip side, of course, as Jeff knows, is that then when you get a major award with all of the attorney's fees and and the multiple years of attorney's fees, and then you're also talking about treble damages, that is a major hit to the city, and the city self-insures and deal and pays these things out of, like I said, the operating budget. So that's where my concern about our fiduciary responsibility comes in. So I think, definitely,
Dr. Bach, I really want to move on to.
Yeah, the May would be a great change.
Thank you. Thank you, Councilor Bach. Thank you. Section 5, all violations of this ordinance by any offending member of law enforcement shall be reported in writing, including the name of the offending member of law enforcement, to all City of Boston government agencies and departments which have any oversight responsibilities for the Boston Police Department, and to all state agencies which have any oversight responsibilities for law enforcement agencies or departments. Such reports shall be a matter of public record to be published at least annually by the City of Boston, and all such reports shall be made freely available upon request by any member of the public. Councilor Mejia, I think that this is a direct response to your concerns about overly aggressive officers, in that if they have been found to violate, their name will be public. Law enforcement agencies of the City of Boston, around the City of Boston, and the state will all have it. And anybody could, I don't know, on their birthday, say, I want every officer that violated this law, and they could be given that information. So I think that might balance what you're concerned, short of dealing with them directly through other means. So I just wanted you to know that. Councilor Mejia, you still there? I think it's just a technical thing. She'll come back. Councilor
Anymore. My internet is unstable, but I'm.
Councilor, we'll go to Rasan right now. You raised your hand.
Thank you. Hopefully Councilor Mejia can hear this, but the reporting system, the statewide reporting system, will be the post system, or the peace officer standards and training, which is also responsible for collecting information about police misconduct. And they'll have a record of it, depending on how egregious this incident is or what that officer's history of misconduct is. They could begin proceedings for decertification. So that's also a potential solution for an individual officer. But to your earlier point around individual financial responsibility, until we do something with qualified immunity at the state level, we're still going to have that issue.
Okay, thank you for that. And I did hear that, but my internet was off a little bit, but thank you for that.
Thank you. Severability, this is kind of form language. Any portion or provision of this ordinance is declared invalid or unenforceable by a court or competent jurisdiction or by the Office of the Attorney General. The remaining provisions shall continue in full force and effect. Effective date, and then this is the 90-day language that we discussed last time that Councilor Arroyo and Councilor Campbell agreed to put in. I had one suggestion, and that is, would you be open to that in any time there's a deployment of the KIP or the CCA in the City of Boston, that body camera footage must be made available within 10 days or something to the public?
Yeah, I would love it.
Yeah, I want to see it, right?
Yeah, no,
Okay.
I agree with you.
Okay.
I think part of the issue with the reporting, to get to like the accountability measure of this, it's one thing to write down in a report, such and such saw this thing and this is why he did it. But we know that sometimes, unfortunately, police reports and police testimony is not as reliable as what the video footage will show. And so I would love to have them have to be required to save that video or to do something so that an outside, whether it's post, whether it's OPAT, whether it's us as counselors, can see that and make a determination as to whether or not the violation occurred or not. I think that would be great, because part of my concern is if it's a yearly report and you say that in February, then what's the point?
No, I want it anytime, even if we find that there's no violation. I just feel that because of the as you described it eloquently, the indiscriminate way in which these weapons are deployed, we should always know why. Even if ultimately we determine the person was well within their rights, the officer was well within their rights.
I also think even in that situation, it's a helpful training tool for BPD to have that footage, both for when it was right and when it was wrong.
So the opposite, not the opposite, but along that vein then, would you be open to failure to save the body camera footage or failure to have body camera footage would be considered a violation also of this ordinance?
I think, and this is where there's certain instances in courts where the absence of evidence that you should have is considered an act of that the evidence is actually taken in light against you. The lack of having something you should have actually means that it must have been bad, something like that. I'm butchering that language, but Rasan and Jeff, I'm happy with that, but you might be able to sort of, you do civil court stuff obviously much more than I do, how that works in those courts.
You trying to get a Bowden instruction in in here?
Sounds like, right?
The fact is, there were no cameras. Remember?
Yeah, this was the issue, and then the cameras
That was the issue.
And then the cameras that we did see obviously were incredibly distressing as far
And
as
cell phone footage of other people. Thank goodness some people had it, but the fact is that we didn't have. I mean, we have a lot of allegations, and the police were, had things thrown at them. And I said this before. It'd be great for us to just have the footage to see, and could justify that some of their action. I don't know that there could be, but the fact is, I would like to know if there's a way in which we could marry the not having footage and a violation of this ordinance, or it doesn't. I don't know. A better lawyer than me, please.
I like it, but if Jeff and Rasan, who are better civil lawyers than me, have a way to do that language clean, I like it simply because I think it adds accountability measures here.
I think it might be difficult to make it a violation. You certainly could put in that it has to be maintained and made public within a period of time. Councilor Arroyo is correct that a negative inference could be drawn against any police officer who doesn't supply this, particularly if they're required to maintain it and supply it. My only question, and this I'm not an expert on, is what the collective bargaining agreements are with the police in terms of body cam. Yeah, and I just don't know what the contract language is and what the requirements are in the CBA.
And I think currently that's a stumbling block with body cam footage because a lot of officers who work these details or these protests or gatherings are there on overtime, and their agreement is that they don't have to wear body worn cameras for overtime assignments. It's only on regular duty. So we would, there might be officers who are there on regular duty, but the overwhelming majority of officers who on May 31st, they were there on overtime. And so there are very limited amounts of body worn footage. So the negative inference language that's in this ordinance could be helpful, but it might not unless something's done with an agreement like this.
Or, I mean, it could be they would claim it violates their union contract to attack it.
Right.
Yeah.
Okay, well, I tried.
I'm happy to look at it if there's a way for us, maybe when we look at that contract, because I have not looked like deeply at the contract to see if there's a way to do it. I'm happy to figure out a way to do it, Madam Chair, if there's a way to do it. If there isn't, then we're tried.
If nothing else, I think we could put in something about if body cam footage is available, then it must be maintained and made public within X period of time.
That we discussed, absolutely. Yeah, that was my suggestion, is that we have that. And actually the trigger being not if it's available, that anytime a kinetic or KIP or CCA is deployed, footage needs to be given.
If the police are wearing those body cams, as Rasan said about whether they're required to do that, they may not be required to have a body cam. So
right.
That's why I would put in the if available, anytime those weapons are deployed. Absolutely.
So instead of going back and forth on, if available, those kind of scriveners, it looks like we agree on the overall concept, right?
Yeah.
So I can go back and forth with the counselors on some language, and I can also reach out directly to Jeff and Rasan to make sure that language is finished. I I'm also, I mean, I'll see if I can, it looks like that would be the only thing. Further research on the contract language and body cams in general, if there's any way to, I don't know, rebuttable presumption. I don't know if we can do that, but those are two things I'm happy to do some legwork on and get back to lead sponsors and to Jeff and to Rasan and see if that can work out. But other than that, this is it. I don't know if anybody has any concluding remarks or suggestions before we go ahead and end this working session. We went through it.
Just a thanks. Sometimes when I start these sessions, I get so like worked up to just get to the work, I forget to say the thank you. So I want to just make sure I say thank you to the Madam Chair for her thoroughness in making sure that, you know, there's some real good thoughtfulness there to service animals and just these different angles that I really appreciate that you take. And then in general to my co-sponsor, Andrea Campbell, Councillor Campbell, who's really helped lead on this, and Jeffrey and Rashawn. This wouldn't be possible without you. I know Somerville beat us to it, and like Councillor Bach, that hurt me personally. I felt very upset about that. I was grateful they did it, but I felt a type of way about that. And so at a minimum, we have some better language in here in some places than they do. So we'll have that forever. But you know, we're beating Cambridge at least. So there you go. So thank you.
Wow.
It's possible. So thank you, everybody.
All right. Well, thank you. We heard from lead sponsor. I don't think we need to hear from anyone else. Have a good day, and we'll get back to you with those suggested language.
Thank you, everyone. Have a good
Thank you.
weekend.
Thank you.
Bye. Adios.